Hello again, Andrew Cobin here, board certified specialist in estate planning and probate law. Here today to talk about probate. So we've addressed in a lot of our videos about means to avoid probate, but we haven't actually gotten into what is the process of probate. So let's do that right now. So probate is the process of transferring ownership from the individual who's died to his or her heirs. It's also the process for satisfying all of the debts and obligations of that individual. Right? So the authority that is given to someone to transfer those assets, to take charge of those assets, is an authority granted by the court through something called letters. So we have the situation where someone has died with a will, and that will names an executor. When that executor applies to the court and the court approves the appointment, that person, that executor, receives something called letters testamentary. And with those letters testamentary, that's what opens up the doors. Right? That's where the executor can now go ahead and talk to those institutions that refused to talk to him before, take charge of the assets, etc. So we can think about probate really in three phases. So that first phase is making application to probate. So we just talked about that. You actually apply to the court to become the executor. And then identifying the assets and the date of death value of those assets. And all of that needs to occur within the first 90 days. And the second phase is identifying what all the debts are. Right? So we notify the known parties out there to which the decedent owed money to. And we also run an ad in the newspaper to give an opportunity for all the unknown parties to bring forward their claims. Now that's that creditor notification and identification period ends 3 months after the first run of the advertisement in the newspaper notifying all of those creditors to bring claims if they have any. From there, the executor is going to satisfy those claims that are valid and deny those claims that aren't valid, or maybe negotiate some of those claims down as well. The third phase of the process is meeting all of the court's obligations. So that's going to be paying the court costs, paying the attorney's fees, submitting an accounting to the court that really accounts for every cent that has gone into the estate and that has been paid out of the estate. And of course, it's distributing the assets to the heirs. So that's probate in a nutshell. It seems pretty easy on its face, but really the proof's in the pudding. Right? So there's a lot of ways for a probate to go south. As a starting point, probate is a matter of public record. Right? So those assets that we submit to the court, those assets that are become a part of that accounting, are part of the public record for people to see. And also, not every asset's going to go through the court process, but we have to list those assets that may be transferred via joint with right of survivorship, because those assets could be made part of the court process if it was necessary to pay debts. Right? So our assets become part of the public record, and a lot of folks just aren't keen on people knowing what they have. The other thing to consider is that probate's an excellent avenue for someone who wants to challenge the estate. Right? It provides more opportunity, more options, and better certainty for the attorney in getting paid to challenge an estate through the probate process. All right? So oftentimes that in and of itself is a really good reason to avoid probate. And the third reason, it has to do with the costs. Right? So that there's the dollar costs of the court fees, which truthfully aren't that arduous. In North Carolina, the court fees are capped at $6,000, but it is an expense of the estate. Particularly for those dicey probate proceedings, you need an attorney. Right? And the attorney's fees are probably the lion's share of the cost in an estate. Right? And a lot of firms, and ourselves included, make a good living doing probate work. Because it's difficult, it's very niche. There's not a lot of attorneys that do it, and so we're billing by the hour to prosecute this probate administration. But there's also a separate cost, and that's more of the human cost, right? So the probate process is a long process. I like to tell clients it's a marathon and not a sprint. And for a lot of folks, they're grieving, they're trying to get past this, and yet you have this court process that's dragging on and on, Not every one of them, but sometimes multiple years. You know, I've had probates 3-4 years in length, and they were particularly messy. So those are really good reasons to avoid probate, right? The fact that it's a public record, the fact that it provides easy avenue for someone to challenge the estate, and the costs. Right? So those by themselves are really good reasons to avoid probate, particularly because it's so easy to do so. So we like to encourage our clients to avoid probate, not in every situation, but in a lot of them. So that's probate. We'll talk a little bit more about some of the other aspects of probate. One of those that come to mind is dealing with real estate, and that's a whole separate animal, and it's going to require a whole separate video to discuss that. But that's it for today. Hope you guys enjoyed it, and look forward to seeing you again in the future. Take care. If you liked what you heard today and found it as fascinating as I do, feel free to share it with a friend by clicking on the link below. Or if you'd like to learn more or speak with one of our qualified estate attorneys, visit us on the web at ncestateplanning.com. Thanks again for joining us, and look forward to seeing you again soon.